Well, welcome back. It is day three, the final day of the Annual Information Security Summit 2021, brought to you by NASSCOM DSCI. And once again, as promised, we bring back to you another very, very interesting session. It is a plenary session on PDPB, enabling personal liberty, digitization, and innovation. And joining us for this session is another esteemed set of panelists who will be, in fact, sharing with us their valuable insights and thoughts on the topic. And I'm going to one by one quickly invite on stage, starting with Mr. Prasanto Roy, who is Senior Director, FTI Consulting, and Dr. Ralph Sawyer, European Commission. He represents the European Commission. Amber Sinha, Executive Director at the Center for Internet and Society, and Shinjini Kumar, the co-founder at SALT, will be sharing with us their valuable expertise on this subject of PDPB, enabling personal liberty, digitization, and innovation. So we can, as you may be able to see now, we have on our screens all the panelists, and I'll hand it over the session to our panelists to take it further from here. Thank you.
Thanks very much, Simriddhi, and welcome. Delighted to be here on this panel. The PDP bill and whatever else it's going to be called, maybe the Data Protection Bill, the Data Protection Act, finally at some point of time. It's been long in the making, from the Supreme Court judgment in 2017, and then, just Justice Sri Krishna Committee, the first draft, a second draft, then, something that we've all been struggling to guess, and we still don't know what is actually going to be the kind of text of the bill itself. But I think the report has shown us a kind of direction. There have been, of course, various versions floating around that we've looked. So I think what we will do is very quickly jump into a discussion on, based on what we know, where this is headed. I think clearly a few things we know by now. One of them is that the bill does include not just, it was privacy to start with, right? It was a privacy bill. And it was very clear from early on that it wasn't just privacy. It was a lot about data, about leveraging data, the economic value of data, data sovereignty, that the government was overall very interested in. And not just with this bill, but with a whole lot of, things like the e-commerce draft bill and so on and so forth. Today, we know that non-personal data is very likely to be part of this. That's what the report says, and no reason to believe that it's not going to be there. So the non-personal data aspect is one thing that has, plenty of discussions have happened on the need to do that, the need to drag in non-personal data into this, what it means for a whole lot of companies which are, dealing with data. Do they need to end up sharing their data out for whatever is defined as public good, and a whole lot of other things? The scope of the application, and I think DSCI has put together a nice analysis on this overnight. So that's very helpful. But they've suggested that we look at only the context of information available in the digital domain. So non-digitized data would not be governed under this bill. So it's only digitized. So at least there's clarity on that. The criminal penalties remain fairly stiff. So that's one thing to keep in mind. And of course, there remain very strong exemptions for government entities. So kind of dial down or watered down liability there. And I think that's one of the areas of dissent that has come in from some of the members. And the dissent notes, at least, have been public well before the report itself. And I think the last thing I'll focus on, there are quite a few other points, but data localization. Now, data localization, I think the waters were tested with RBI's April 2018 legislation or circular, which mandated that payments data had to be localized, and stored in India and only in India. And it's been much water has flowed under the bridge. There have been the banning of several card entities, three of them, two of them, Amex and cards, and I think that's work in progress. But it's been interesting there because even processing, which is not explicitly sort of banned, the way data has been kind of mandated to be brought on soil, even if it is processed outside, seems to put a bar even on processing. So now from that test bed, we are clearly seeing a direction where all data in all areas, whether it's geospatial for maps, for Google Maps or Apple Maps and so on, and pretty much everything else is going to come in the ambit of this data localization mandate which is sought to be brought through this bill. So I won't go further there. I think these are some of the key points. There are a few other things on accountability and the transparency practices, um, the timeline and what we expect to see there. But I think that's going to come out from some of the panel itself. So what I'm going to do is ask my fellow panelists to quickly jump in and come up, start off with just 3-4 minutes outlining what their thoughts are on the way forward and on this bill, where it stands, what the issues are, and flag maybe their top 2-3 concerns, and then we'll take that up for discussion. So we'll start in alphabetical order. So Amber, can I ask you to jump in first? Sorry, Amber, I think you're on mute. I'm not sure if. Okay, Ralph, could I go to you while Amber rejoins back? I think he's having some trouble with his audio.
Yeah, sure. Happy to go first. Although, mind you that I'm representing a foreign government, if you wish. I'm representing the European Commission, which is the executive arm of the European Union. So
Right.
We look at this from an outsider that fully respects, of course, the sovereignty of the Indian legislative process, and I want this to be clear that those are some reflections, but it's not meant as a criticism or anything. I think what and I have glanced over the report, which is long, and so I can certainly not say that I have already digested all the details. I think what struck me most is actually that things that were already there, issues that we had identified. We also made submissions in the past as part of the public consultation, have not changed. So it's therefore probably natural that I would come back to those. I think one, there were essentially three issues where we had certain questions whether the draft is ideal or should not perhaps be strengthened. One concerns, I think, the, let's say, horizontal scope, the coverage, scope of application of the data protection bill, and in particular when it comes to possible exceptions either in the draft law itself or the possibility for the government to create additional exceptions for processing by public authorities. From our perspective, if I look at our rules, they have a general coverage. We even have two data protection laws, actually one that covers commercial operators and public authorities in general, and then we have a particular data protection law for data processing by criminal law enforcement authorities. So we try to be comprehensive, and I think it makes sense because data in today's world flows between the private sector, between different private sectors, but also between the private sector and the public sector. And actually, sometimes even the nature of entities might change from private to public or reverse. It's, I think, to ensure the trust in the digital economy, it's important that wherever the data goes, it is protected. And I think I also believe that it can be protected in the same way with the same principles, rights and obligations. Of course, data protection, privacy is not an absolute right, so it is possible, and we have that in our rules as well to have certain limitations, for instance, but those should be selective where it's necessary, and they should be done with the balancing of interests in mind, so proportionality, as we would call it. So it should be framed, limitations should be framed, rather than exempting wholesale certain activities or entities from the application. That's the first point. The second point is on, let's say, the data transfer question, and I would say I have the impression there's a lot of focus on one aspect of that, which is data localization, and that is certainly also of concern to us, in particular as a trading partner of India. We believe it's not healthy for the economy. It's not healthy for the internet because it risks fragmenting or splitting the internet. And it's not necessary. We believe there are other solutions. I mean, depending on what the interests are for data localization. For instance, if the interest is to have access for law enforcement to data, we believe there are other ways to do that through bilateral or multilateral arrangements, such as, for instance, when it comes to criminal law enforcement, the Cybercrime Convention. But that's only one aspect of the transfer issue, where we would think that maybe the bill is overprotective. But I think it's also potentially underprotective for the data that can actually be transferred, because we don't see that the draft in all situations ensures really a meaningful protection or safeguards for the data that can transfer. And we believe, I mean, there might be sometimes a requirement for consent, but consent is a very binary tool in a way. You can only say yes or no. You can either my data can be transferred or not, and individuals might not be. It might be difficult to sufficiently inform them to make a good choice about that, and there's no intermediate way. I mean, because maybe people would be ready to allow the data to travel if there were sufficient safeguards with that. And I think that's where other tools come in, and I would be happy to later on maybe dwell on those, such as, for instance, model contract clauses or the like. And the draft doesn't provide for a toolbox, and I think it would be important to have various instruments or grounds for transfers with protections when the data goes across borders. And the last point, just briefly, is it's not the substance, but it's the compliance part, and in particular oversight and enforcement by the Data Protection Authority. We very strongly believe that it's important to have an independent Data Protection Authority. And I think there have been improvements in the draft to for instance, make the appointment process to shield it more from potential influence. But there's nevertheless, there are, I think, possibilities or powers given to the government, for instance, to give directions to the Data Protection Authority, and not just on policy questions, potentially even on enforcement questions. And we believe that's perhaps not a good idea. In particular, if the data protection law would cover, and as it should, we believe, the public sector, then of course it cannot be a good idea that the public sector could at the same time give directions to such an authority. I think that creates a conflict of interest. So I think there's a trend globally to have truly independent data protection authorities, and that's good for individuals, but it's also actually good for those that are controlled by it, because it ensures that there's a neutral arbiter that both sides can trust in. So those would be maybe my 3 points: scope, the transfer issue, and oversight.
Thanks very much, Rolf. I think that's, I mean, even though you're coming in from an outside-in view, I think that's an excellent kind of summary of some of the challenges that we've been also discussing with it. And I would, going forward, would like to understand a little more about how some of these things are better handled or handled differently elsewhere, including the kind of issues that data localization is attempting to solve. Because, the government says that, oh, we are not really able to leverage the MLATs and things like that when we actually need law enforcement access. But I'll come to that. Amber, can I come back to you? Hope your audio issues sorted out. Your 3-4 minutes, please.
Hi, Prashant. I hope I'm audible
Yes.
now. So I'll go back, I think, echoing a lot of what Ralph said. I'll go back to where you started from, Prashant, in terms of the genesis of this draft itself. So it goes back to the Puttaswamy judgment, where there was a commitment made by the government to the Supreme Court that it would create a law, and then the logical conclusion would be that the law should draw its contours from the definition of privacy in Puttaswamy 1. And I think the important thing to note there is that Puttaswamy established privacy not just as a negative right, which is not just in the context of a vertical right where you protect it from undue interference from the state, but as a positive right where there is a positive obligation on the state to protect the privacy of citizens, both from private actors and from the state. So that being said, I think what we see is over subsequent drafts, the waters have been muddled a fair bit by mixing several issues at one go. The primary objective of this bill ought to be privacy and data protection, and by bringing in questions of data economy, how the government should facilitate it, non-personal data, I think it leads to much more confusion. I think another thing that we need to remember is that the Data Protection Authority being visualized under this law is actually going to have a uniquely broad mandate as opposed to sector specific regulators or licensing based regulators which have a narrower scope of regulation, or regulators like competition and antitrust regulation where there is a very high threshold that you need to meet, or even something like intermediary liability, where safe harbor means that the point of regulation is non-regulation actually. So every second business is, in some senses, a personal data processing business. And uh, given the very broad mandate that this law has, by trying to introduce other things, it actually confuses the matter. The, it is fine for other policy documents that the government has, for instance, its e-commerce policy, its AI policy, and things like that, to go into those terrain. But I think it's problematic if the data protection law itself looks at concerns which go beyond privacy and data protection and looks at competing what it itself uses competing objectives of digital economy. So I think that is where I see a lot of issues with the law, issues which relate to data localization, issues which relate to the sort of very broad mandate and a fairly unrestricted mandate that the central government will have with regard to regulation and governance of non-personal data, as well as the exemptions that Ralph spoke about, very, very broadly, and in some cases vaguely termed exemptions rather than being more specific. There is a lot of language which is actually self-contradictory when it comes to those exemptions. On the one hand, we talk of the standard of necessity which draws from privacy jurisprudence. On the other hand, we talk of expedience, which is actually a contradiction in terms. So I think those are some of the big issues. The other thing that I would highlight is that for a jurisdiction like India, which has where these businesses have operated largely in a regulatory vacuum, when we move to a robust data protection law with a fairly high legal mandate, you need to phase things out. You need to have a clear strategy on how capacity building for the industry also needs to be done. And in that sense, one of the things that we've recommended at each stage is to have a phased implementation of the bill, and particularly when you're looking at criminal provisions, when you're looking at very high monetary penalties. What we also need to ensure, particularly for smaller actors, on the preparedness that the industry has to implement the law as well. And I'll pause on that note.
Thanks very much. Again, great context in for the discussions. I'd just like to mention for those who've joined in late and can't see the titles against the names. So, Dr. Ralph Starr, who just spoke, is from the European Commission. Amber Sinha is from the Center for Internet and Society. He's a lawyer. And I'll move on to Shinjini, whose designation title I think is visible there. She's co-founder of Salt One. But I would also, Shinjini, like to draw on your long experience, first of all with the regulator itself, with RBI, but subsequently as consumer head of Citibank, where you've dealt with this whole data localization piece, which I think was a sort of test bed for what is being attempted to be done here. And now as a founder of a startup which would deal with a lot of data, where you expect to see potential compliance burdens. So how do you see this playing out?
Sure. So first of all, Prashanta, thank you for having me here. I joined because I thought I'll learn a lot, and I already started to. So Ralph, Amber, thank you for your insights. And I'm just going to add a little bit from what they have already said. One thing that and I've had 30 years of experience in Indian financial services, both on the regulator side, almost 50-50 divided between being a regulator and being on the other side of the table. One thing I have realized is that when you design laws or rules or bills or acts, the something that Amber talked about, the execution, the idea of how do they become codified into the actual behavior of organizations, which are the entities which eventually face off to the client, right? Because there is always that market layer between the lawmakers and the eventual user, which in this case is every human being, including employees, including me as a person. So I just think that from looking at what we have looked at so far, it is because the scope is so large and because it is also all encompassing and it has sometimes conflicting or very overarching objectives. I think I'll be very curious to see how that will happen, because one thing that happens in jurisprudence, in when an actual law gets made and gets decided through the process of courts and lawyers, is that over a period of time you begin to get clarity on some of those implementations, and then there's the case law, and then you go and take a position, and sometimes your position is defended and sometimes your position is not defended. One of the things that I think common across the world in regulatory atmosphere, but definitely so in India, is that you don't normally have that process. Regulated entities don't go to courts against their regulator, barring very, very exceptional situations. So therefore the interpretation of the law by the regulated entity and the regulators, and there is no such thing as saying based on a stance taken in a certain situation by a court, I can confidently take this stance. Everybody is all the time guessing and blind guessing, and sort of there's this game that goes on. And I just hope that because data is this subject is so important and so all encompassing and has such severe repercussions for how we engage with users or how we even do business in the digital age, that I'm just hoping that it will be more thought through. I will just give you a very simple example. You took the example of data localization, where you yourself talked about the example of processing. So the definition of what constitutes processing, what constitutes T plus 24 hours, what constitutes T, all of those things are things on which industry is forced to take a call, because as a player you don't have the option to not do business, to stop processing, right? I mean, obviously in the end we all saw that some people had to stop processing, but to start with, that's not where you go. So you take a call and you start in good faith. Very rarely do people not do it in good faith. And of course you can get to the point of saying that it's not good faith because of timelines, or because you didn't listen to me, I didn't listen to you, I came to ask you, you didn't give me the right clarification. There's a lot of that begins to happen. So obviously we've seen that in that space of data localization, that eventually industry takes a call is not right. That can be prevented upfront by, or you go by with this idea that every single time, if the regulators have said something, I will take the most conservative interpretation of it and stop doing business. So like in Citi, I've done that sometimes, right? So we've said, particularly on AML or KYC, we've said we'd rather close 600,000 accounts than take even the most minor risk of engaging with the regulators and saying, no, we think this is not incorrect, right? So, but that's not the way you can do business. So obviously, especially in an evolving stage, especially if you're a startup, especially if you're trying to do new things, you can't take those calls. So therefore, you will have to come up with that. So the point that I'm trying to make is that when you implement complex laws, all encompassing laws like this, the implementation of them needs to be thought through. The design for that implementation needs to be thought of upfront as well. So therefore, the independence of the data monitoring authority that Ralph talked about, the constitution of that, the model of engagement with the industry, with the regulators, with other jurisdictional authorities, just creating that jurisdictional roadmap up front, so that a police constable sitting in Chhattisgarh doesn't go and arrest somebody because somebody in Chhattisgarh goes and files a case against somebody. So all of those things are important. I'm not saying that they will not be taken care of, but I'm saying that they need to be taken care of. The other space where we've learned a lot, and I'll not talk about it right now, I can talk about it later, is in the AML space. Once an act gets written, once a bill is written, nobody wants to take a interpretation of it. You always go and say, and then there is hardly any machinery for that. So that's one sort of expectation I would have. The second expectation that I have clearly is that government agencies, and Ralph talked about their coverage and whatever. So I'm not looking at it as a problematic issue from the perspective of personal liberty, etc., which are also issues. I'm not denying that, but purely as an industry participant, I'm thinking that government agencies have an opportunity to show up as examples of doing this well, of actually protecting your data well, because they are always going to have more data than individual players in some sense, right? But that's again something which I don't think we've seen. So my example is the Aadhaar, right? All of us in financial services industry, we have requirements of encryption, what do you call it, digital lockers. We've spent millions of dollars to create all of those security infrastructure, and it's a good thing. I definitely think that's a good thing. All concerns on data are valid concerns. There's absolutely no doubt about it. But on the other hand, to send a courier, you have to give your Aadhaar. To get a vaccine, you have to give your Aadhaar. And you don't have to give, and I have had this fight many times. You can't just give last four digits. You can't give a hash number. There is no such infrastructure. You have to, any agent will take a photo of it in their phone. You have no idea where that is going. So you can't have a situation where one set of participants that are covered participants who are also the digital citizens, or people who are building in that space, have onerous compliance, and on the other hand, people who are dealing with physical data, or like, I'm not saying that physical data should not be handled. It will always be there. But if we want to move to a position where we want to prioritize security and data and digitization, because all of those are our objectives, then we can't have a situation where we can ignore how it is used by other authorities in other forms. So I'm not saying that you should dilute your norms for digital players, but we must think about how to build a level playing field in some ways. So those are my two concerns.
Okay, great. Thanks, Shinjini. I think excellent roundup from a very different perspective, and you brought up some interesting points, which some of which I will park. For example, your point that no one really pushes back against the regulators. Now, that's true of the sector you came from. The RBI is a very, very strong regulator, and I don't think anyone really takes the RBI to court. We have seen legislation being pushed back on, for example, the intermediary guidelines. You had WhatsApp going to port. I think when there is a very existential issue, and I'd like to park that with Amber for slightly maybe 5-10 minutes down, on whether you see that potentially happening here, and I'm sure civil society will very likely go to court. Okay, that's one thing which is clear. I don't know if companies and corporations will, if they see existential threats, for example, the mandate for sharing non-personal data through various means for public good, etc., etc. So I'll just park that with you. Ralph, I'd like to address to you how you see. So one was, I think, the point that you made about how some of this could be done better and or differently, perhaps, including the data localization purpose, which is law enforcement access to data and so on. And the only in India part, I'm not sure how to really articulate the purpose of that. I think there's a feeling that if data is stored outside, it is accessible to foreign governments and so on and so forth. So I think that's one question. The second one I'd like to put to you, since we have an audience here of information security professionals and so on, what is likely, how is legislation revised in terms of, refreshed in terms of impact? I don't know if you can hear me clearly. Hear some bit of echo. So maybe if the others could just hit their mutes. Oh, yeah, that's good. So, so for example, GDPR. Now, GDPR has been challenging for a lot of, I know a lot of Indian services companies which supply to Europe and which have struggled to deal with it and come to grips with it, etc. So, do you have a process of refreshing and figuring out, what's going right and wrong, especially with organizations and the ease of doing business while enforcing this? And is there some learning from that we can? So that's one question I'd like to put to you.
Okay, so thank you for on the first part. I mean, again, it's better for you to judge what are the motivations, the objectives that are pursued with data localization. Let's say usually I see two main reasons for that. One is maybe sort of boosting the data economy. And on that, and maybe creating a pool of data and things like this. As much as this is a legitimate interest, and it's one that we also pursue in the European Union, I think there are other ways of doing that. We are just in the process now of creating various instruments to facilitate data sharing, data pooling, data altruism, as we call it, so that individuals that are maybe ready to share the data for public interest purposes, for instance, can do so. So I mean, there are ways of doing that without sort of sealing oneself off from the rest of the world. Maybe also because you have an interest to actually have a more diverse data set, which also includes data from others. And when it comes, and then the second objective that is usually, I think, invoked is law enforcement, criminal law enforcement, I mean, national security. And I think, I mean, certainly, for instance, on criminal law enforcement, we think it's better to try to rely on bilateral or multilateral instruments, and that's what we are pursuing. We have some bilateral arrangements of I mean, for various times and various levels of sophistication, mutual legal assistance treaties, but also more modern agreements. But we have also, in particular, at multilateral level, the so-called Cybercrime Convention, and we have just negotiated, and it's a global instrument which has currently, I think, something like 65 state parties, and it's growing. It's growing at a good pace, and includes, I would say, many of sort of important jurisdictions that hold data also. Such as the US, such as I mean, our member states, Japan, Australia, various others. It's really global, and we have just negotiated a second additional protocol to that convention, which sort of modernizes the tools that are available, and that those are cross-border tools, tools for cross-border investigations, both in terms of speeding up mutual legal assistance, so expedited forms of mutual legal assistance, but also direct access in the sense of direct production orders, orders across borders to service providers, companies in another jurisdiction. But of course, with a set of safeguards and with limitations and safeguards, including, I mean, procedural safeguards, but also data protection safeguards. There's a dedicated article on that. And I think that's a much better way of going about this. It allows each of these parties to also gain access to other data, but do so in a regulated manner, in a manner that everybody has agreed to, and which includes the necessary safeguards, and also, for instance, sometimes includes notification to the party that hosts the data. So I mean, there are ways to do that, and they exist, and I think. Again, that avoids that for the purpose of law enforcement, you shut yourself off and create data localization rules. And then the second question, if I understand well, was more sort of how do you adapt your data protection regime over time, if I can summarize it like that. I mean, first of all, yes, like any new law, I would say it always creates some issues at the beginning. In particular, I think companies need to get used to it. In Europe, and of course, I can imagine even more so you mentioned Indian companies that maybe aspire to the same kind of safeguards. I mean, first of all, of course, they are not covered by the GDPR. There's very, very limited circumstances where they would be directly covered. What they are probably covered by, it might be a contract that includes data protection safeguards, which is not the whole GDPR. It's the most essential safeguards under the GDPR. And of course, I can imagine if you are a foreign operator and maybe in your domestic law you don't yet have a data protection law that creates additional issues and a learning curve. But I think we see a lot of this changing relatively quickly over time as companies get used to it. I think companies most of all want legal certainty. They want to know what rules are in place and how they are interpreted and enforced. And I think there again, the Data Protection Authority comes in, and I think that's the one that can help to adjust over time, because I think what our data protection authorities have done, and they work, we have national data protection authorities, but they work together in a board at European level. And they have developed a whole series of guidelines. I think since the entry into force of the GDPR 3.5 years ago, we have probably 35 sets of guidelines that have been developed on all the major concepts in the GDPR. And they, of course, break this down to a much greater level of detail, and they give practical examples of how these rules apply. I don't know, how do you do a data breach notification? What are the steps to go through? What are certain concepts in the law? How are they understood by the enforcers? I think that's very crucial to have an authority that does that, because a law has to stay at a level of generality. But then on top of that, they are also developing guidance and best practice guides for emerging technologies, for instance. So we have guidance on, I don't know, how the GDPR applies to blockchain technology, how it applies in the AI context, how it applies to automated driving. No, that's not the right word, but sort of cars that go by themselves. And where is other sort of new technologies that, of course, I mean, they develop. You cannot predict all of this. The GDPR is technology neutral. I think it can be applied to any technology. But of course, you need guidance as to how specifically one principle, for instance, applies to the financial sector, or how it applies to, I don't know, a certain technology sector. There are differences. And that's what data protection authorities can do and should do. They can adapt these rules over time to a changing environment. And I think they're much more flexible in doing that than if you would need legislative changes all the time. So I don't know whether that's the whole answer, but that's a big part of the answer, I would say.
Okay, great. Thanks. So Amber, let me come to you on this question of, what is likely to be the legal path forward, and what should, let's say, organizations here which deal with consumer data, and I understand as civil society, you are looking a lot at the, at the individual's rights issues. But from a company's point of view, so for example, global social media companies, which may be looking at a situation where they violate their typical privacy frameworks and policies, if they are mandated to verify users, for example, or they lose their safe harbor and so on. So are there situations in which, I mean, do you think companies should be really looking at anticipating major impact and therefore pushing back? What is the sort of legal pushback that you expect to see if things go as the report seems to suggest in the final draft of the bill itself?
So I think there are multiple issues that could arise. So I think also going back to what you mentioned earlier, there are two situations. One is that the law itself or specific provisions of the law might be challenged by private actors as being constitutionally invalid. So which could be, I think, more in the nature of provisions that relate with exemptions provided to state agencies and whether they are aligned with the definition of privacy as defined under Kutaswamy 1. The other question is about the regulators' jurisprudence itself. And there, I think, going back to what Shinzumi was saying, the key thing for a jurisdiction like India, and here I'll take two examples, one domestic example and one international example. What would be extremely necessary is guidances from the Data Protection Authority on specific aspects of the law. So the kind of non-binding guidances, for instance, that we see from SEBI in India, or the kind of Article 29 working party opinions that we've seen for years in the European Union. So I think though there are a lot of aspects of the law where there is a lack of clarity on how, as a data processor, as a data fiduciary, you are supposed to uh, meet your legal requirements. And on that, I think what we need is a very active regulator to provide that guidance. Uh, the question of specific provisions and the specific issues, the kind you mentioned, which might relate potentially to civil liberties issues, and whether the restrictions that are placed on privacy are aligned with our jurisprudence, or they might also relate to specific issues with regard to safe harbor that especially social media intermediaries might have, where we've already seen challenges to the IT intermediary liability guidelines under the IT rules. So those are all, I think, issues that we might see in the future. Those are the two fronts where, given what we know of from the report so far and the positions taken by civil society as well as private actors in the industry, where we could foresee challenges. But I think the bigger issue for a much greater for a much greater demographic, whether it's consumers or whether it is industry players who are going to be governed by this law, is going to be around very, very specific issues of how they are supposed to meet their obligations and what kind of guidance is provided to them. On data localization specifically, I'll just add to, I think, what Ralph was saying. I think the so since 2018, when the Sri Krishna committee draft bill came out, which originally recommended data localization, we've had significant discourse in India on the advantages and disadvantages of data localization. And I think a lot of data economy or employment related reasons that have been put forth with regard to data localization don't really hold water. Just because the data is stored in a data center in India doesn't mean that it's going to significantly contribute to the data economy here. There are other ways to facilitate and incentivize that by encouraging companies to contribute to data commons, which might lead to more innovation on that front. On the law enforcement access point is actually a very valid one, because in the current scenario, the MLAT regime that we have is completely broken, and it's not
Yeah.
something that law enforcement agents in India can rely on at all. But for that also, I think, like Ralph was saying, there are, for instance, with the US, there are provisions under the Cloud Act where, by being party to conventions, by satisfying certain chapters of that act, we could qualify for bilateral and multilateral arrangements, and that could ease. And there also, I think what would be necessary is a more robust legislation, so that the obligations that we would have under those multilateral or bilateral treaties can be discharged satisfactorily.
Okay, great. So I'm going to just quickly throw one brief question at you, Amber, and then move to Shinjini on this. That for organizations and including startups that deal with consumer data, what do you think they should be most worried about? And they will be using, for example, they may be using government systems for KYC. Now, the government entities in those chains will probably be exempt from a lot of the provisions of privacy as in the bill. So clearly, the burden, a lot of the burden goes on to the startup founders or the CEOs of the organizations involved. So is that a fairly worrying thing for organizations and startups dealing with consumer data?
Yes, I mean, I think uh, the most kind of immediate thing that I see, if I have to point to one provision, is the provision with regard to data localization and mirroring of sensitive personal data. And there's a fairly wide category of data which is classified as sensitive personal data for good reason. And the provision talks about both explicit consent from the data principal, but also it talks about uh, kind of the arrangement to be blessed by the DPA in consultation with the central government. And what we don't know at this point is what sort of mechanism, what sort of procedure is going to be followed for that. To what extent are cross-border data transfer arrangements that companies have now, fairly boilerplate arrangements that they rely on and have always relied on, and to what extent are they going to be impacted? when this law comes into place, which is where I think more clarity and potentially a phased implementation will be essential, if not reconsidering some of these provisions in the first place.
So essentially, for example, if let's say Shinjini's organization is using a foreign a service which is a global service, it could be a card company or whatever, and they are in turn processing abroad, then there's liability on her to get explicit consent from her customers. Is that what we are seeing here?
Yes, I think the explicit consent liability will come directly on the data fiduciary, which is actually collecting the data in the first place. What we might also see is perhaps, again, privacy notices are fairly one-sided, and that consent could be built into it by companies, which continues to amplify the issues that we have with the consent model. That is one of the things that we might see. But I think the other aspect which requires the arrangement to actually be approved by the DPA is what I would be more interested in looking at, because there getting consent is not enough. You actually need to satisfy the DPA that this mode of actually data processing, where you are managing your data or transferring your data overseas, is actually valid.
Okay, so Shinjini, I'll just leave the last words to you since we are out of time. From what you've heard, what are your concerns finally as a startup dealing with consumer data with this bill, if it turns out the way it appears it's going to be?
Sure. So, okay. So one thing I'm learning every day, because I've become a startup founder at a late stage, is how much building a consumer friendly product is about the right design of it, right? And therefore, my expectation in turn from the government that is designing something is to have a user friendly design, right? Now, when I say that, what do I mean? Amber just talked about getting approval from the Data Protection Authority. Now, the word used there is it's not approval, it is something, whatever, it is some kind of an approval, right? Now, the thing is that I first draft something which is in consonance with what I've been told, and then I still go and get an approval. But after that, what happens? So, first of all, that should not be required. I know the law. We are all good citizens. We all know red light, green light. We should be able to follow the law. The important thing is that if somebody doesn't follow the law, then the how do you create correct incentives in the market where people that follow the law versus people that don't follow the law, it's not treated in the same way. So effectively what I'm trying to say is that it should not be up for a toss, that if I get caught, I will see what I have to do, and therefore until then I'll be a cowboy, versus somebody who wants to build carefully. So obviously, as a startup, I coming from my legacy that I come from, I'll obviously want to be very very careful, want to build carefully, and I'm not saying that other startups won't, but obviously there'll be all the different types of players. So some people will try to do that, versus some people will try to say, okay, let's just do it, and let's. It's already happening in other spaces. You know that, I know that. It's already part of that market, right? That And one of the things that happens is that if you allow more people to get away with lax implementation, because you're so focused on approvals, you're so focused on just getting after what you catch. It's one of the fundamental problems we have. You're so obsessed with taking, you're so embroiled in just nitpicking and micromanaging things that come to you, that what doesn't come to you is something that you never get, which is why in this country millions and millions of people's savings are denied to them by various cheaters. But the industry always is at the end of very complicated implementation. So somewhere I think that's one thing that I will expect. The second thing that I think everybody has spoken about, but to me that's a very very critical one, which is the denial of service. So how do you create a consent architecture in a way that consumers have a simple understanding of saying, so for example, and it's not even hard, it's very easy to say, I'm somebody who's absolutely okay, like my husband, he says, what will anybody take from me? So he'll say, okay, take whatever you want, and he really doesn't care. There's a second type of people, somebody like me. I don't care if my data gets aggregated and you take insights from it and you do what you like with it, but I don't want you to use my personal data for anything else, and therefore I will be, I'll do a certain thing. And then there are people who just don't want to be part of that ecosystem even for that. So as long as people understand those things clearly and the consent architecture is simple, people should be able to take one, two, or three, rather than either having to go with everything, whatever the service provider has written in fine print over 35 pages, which cannot be read on the smartphone screen, or getting a denial of service. I think that's kind of the important thing to think about for us.
Excellent. I think that's a great point on the consent architecture and the likely friction it's like, it's likely to bring in if you look at all these steps of, bringing in consent, if, for example, if there is offshore processing and so on. So, okay, we have a lot we could take up from here, but unfortunately, we are out of time. So, I'd like to thank you all, my fellow panelists, Ralph, Amber, Shinjini. Thanks very much for this. And I think this will be available online for others to see if they haven't yet. And it's back to you, DSCI, and to Samriddhi. Thank you very much.